All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear argument in three cases this morning. First is 2079 James Construction Group against Westlake Chemical from Harris County and the 14th Court of Appeals District. Then 2273 Cadence Bank against Elizondo, also from Harris County and the 1st Court of Appeals District. And finally 2802 Lake Jackson Medical Spa versus Gayton, again from Harris County and the 14th Court of Appeals District. The court has allotted 20 minutes for each side in each of the three cases, and we'll take a brief recess between the arguments, concluding them before lunch. The arguments are being webcast live this morning on the court's website and will be available later today in archives. We're ready to hear argument in 2079, James Construction against Westlake Chemical.
May it please the court, Mr. Goles will present argument for the petitioner, and the petitioner has reserved 4 minutes for rebuttal.
May it please the court. By all accounts, this is supposed to be a termination for default case. And in any termination for default case, this court is well aware there ought to be at least 2 notices in the record, right? You would expect to see a notice of default, and you would expect to see a notice of termination. But they're completely missing from the record in this case. And you might ask yourself, why is that? And the answer is actually very simple. This contract never was terminated for default. And we can look at the record itself to see exactly why this contract was never terminated for default. In our oral argument exhibits, we've submitted to you the first exhibit. It's an email sent from the contractor James to the owner Westlake less than a month after they claimed that this contract was terminated for default. It's at the bottom of the page, Defendant's Exhibit 862. This is in early May, again, less than a month after the supposed termination for default. This is us requesting release of the retainage on the mechanical portion of the job that they claim was terminated for default. About $2.7 million was being held in retainage, and we're asking that it be released. The next exhibit, Exhibit 2, is an email from the owner, internal emails amongst the owner, about a month after that. And here at the bottom you have Andrew Kenner, their senior vice president, asking the project director, Abram Quo, hey, I've got this invoice from the contractor James asking for a release of the retainage for about $2.4 million. These are his words, and he says nothing about the supposed termination. He says, do you agree that this is per the contract and do you approve this payment? What does Quo say? I'm okay with it. It followed the contract between the parties. Now remember, this contract allowed them to withhold payment and offset any amounts that were supposedly due to them for any supposed termination for default under this contract.
Was there also a provision that said that payment under the contract or payments made under the contract didn't waive any potential remedies or something like that?
Sure. And we're not arguing waiver on this point. We're simply illustrating to you there's no mention of the supposed termination for default or safety or anything at this time. And think about it common sense-wise. Would an owner who just terminated a contractor for default, who is about to sue that contractor for millions of dollars, willingly pay millions of dollars to that contractor? I mean, they turned around and they sued us about Christmas Eve of 2014, about a year and a half from then, for $20 million. It stands to reason that they're not going to willingly pay us $2.5 million if they actually genuinely thought at that time that they had just terminated that contract for default. We'd ask for you to turn to the next exhibit as well. This is about a year and a half later. It's shortly before they filed suit. This is October 30th of 2014. What this email is, it's a request for us to do more work on this very same job. Now again, remember their story at trial. at least 3 of their witnesses said, we killed somebody on the job, and they had to get us off the job as quickly as possible because we might kill somebody else. This is them asking us to do more work on the job. And bear in mind, we're still on the job through the late summer of 2013 performing civil work. So this contract never was terminated for default. What's interesting about this, the timing of this email, is it coincides with their trial counsel. If you look at their Plaintiff's Exhibit 219, at this very same time frame, it's when their trial counsel is attempting to identify, in what their words are, the best targets for litigation. So their trial counsel is developing one story, but we look at the project record and it says something very different.
So are you saying that lack of complying with safety rules, whatever, that result in an unsafe working environment does not constitute a default when it was specifically talked about in the contract?
There's a difference between a safety violation and a safety incident. And everyone who testified here, including, I believe, the replacement contractor, testified that the circumstances of this particular project lent itself to safety incidents. Because it's the nature of this kind of job. It's heavy industrial construction. When you have a compressed space and a compressed schedule, safety incidents are likely to happen. And these workers are human beings. So they're not robots. So safety incidents are bound to happen, but you can't necessarily equate a safety incident with a safety violation. And this is the problem with their story. Remember what the jury found. There were 3 submissions to the jury on these express conditions, right? one submission per condition. They were asked with respect to the first 2 whether there was strict compliance, they were asked whether there was substantial compliance, and they were asked whether it was futile to have complied with these conditions. The parties contracted for written notices. Written notices are definite and certain. This court recognized the significance of written notices in Berry versus McAdams. We've cited the case in our brief. It's a 1900 case. It has to do with a materialman's lien. And the statute in effect at that time required written notices to be provided to the owner. And in that case, the materialman stated that he had provided oral notice. And this court stated in Berry, the policy of the law is to relieve the owner from demands upon the ground of actual knowledge and constructive notice because he could rarely defend himself from such claims. Written notice is certain and definite information upon which the owner must act.
So why weren't the emails written notice?
The jury found that they weren't. Remember, with the strict compliance findings, the jury answered no with regard to the first 2 notices. And I think that, and those findings are unchallenged. They failed to find that there was written notice provided under this contract. And if you recall too, there were summary judgments immediately prior to trial. The trial court actually found that the emails didn't constitute actual notice either. So I think what we're left with are these vague statements during meetings.
Actual notice? You said didn't constitute actual notice. I thought it was didn't constitute strict compliance.
The trial court found.
The jury found substantial compliance.
Right.
And would that mean that there was actual notice?
According to the jury findings, the elements that they were required to find did state, yes, actual notice. But I'm just calling attention to the fact that the trial court itself had found that the emails...
But the trial court can't make findings on summary judgment.
No, but that was his conclusion. I think what he was left with, I think, is what the argument ended up being at trial too, is that it was these oral statements at these regular safety meetings that supposedly constituted these notices of default and failure to timely cure.
Let me ask you this. You have a claim for improper termination under section 21.3. Under that claim, would you have to prove material breach in order to get a finding of breach of contract?
No, we argued the materiality on that in regards to the affirmative defense.
Well, but why wouldn't you have to prove that it's material in order to show that there was a breach? What I'm getting at is if you have to prove material breach,
right,
then why isn't the reverse of that substantial compliance?
Well, we would say that it's subsumed within these failures to comply with these particular conditions. We've cited in the briefing Bruner and O'Connor. This court is well aware of the significance. It's one of the most respected treatises on construction law, and it deals with these specific types of provisions, these termination for default provisions. And it states that because of the significance of what a termination for default is, in our oral argument exhibits, we included an excerpt from our damages expert, Brad Bright, who explains it's basically like a death penalty for the contractor, and when you terminate a contract for default, they have to disclose that on future bids, right? It's almost like they're
I
excluded.
understand the seriousness of the issue, but just as a matter of Hornbook contract law, whatever kind of contract you've got, it has to be a material breach, right?
To excuse future further
Okay.
performance.
And so why isn't the flip side of that substantial compliance? And shouldn't that be the standard that we're looking at on the other side's claim?
No, I don't believe so, because I'm long-winded on the Brunner and O'Connor, but what it gets to is that courts routinely strictly construe and enforce termination for default provisions because of the significant and drastic remedy that it truly is. It's unilateral self-help by the owner. So that's why Brunner and O'Connor recognizes that even if there is a sufficient ground to terminate the contract for default, merely failing to take the contractually required steps, which is what we've argued, the failure in and of itself to provide the written notices in and of itself is a material breach of the contract, setting aside whether there was sufficient cause to terminate the contract for default. So we would say, I guess it's inaccurate to say we're not required to prove material breach, but because by proving that they didn't provide the written notices, that in and of itself is a material breach, at least according to the treatise and the cases cited within the treatise.
Do you agree with the respondent's argument that Section 17.2 is an independent basis to affirm, and under 17.2 there didn't need to be notice, or is
No, I don't agree with that
so
at all.
walk us through what the response is to that.
So if you look at the contract, Section 21, I mean, almost the title of it sums up our argument. That section is entitled Termination and Substitute Performance. That is the only provision of the contract, that section, that article, that deals with the subject of substitute performance. You would only be able to terminate, to end the contractual relationship and hire a replacement contractor if you comply with that section. So while you might have the right to intervene and stop work when you see an unsafe condition, you would not have the right to retain replacement contractors and hold James responsible for the costs unless you complied with that section. Otherwise, these provisions would have no, Section 21 would be rendered meaningless. Look at also Section 21.
I thought it did say something about that the owner could recover all costs associated with the intervention.
Right. If there were costs associated with the intervention, yes. But here we maintain, even if we say, number one, there weren't any costs incurred with the intervention, but even if they were, they waived them by failing to submit them to the jury. Remember, all of the damages they submitted to the jury were these termination costs, right? The cost to hire replacement or to safety train the replacement workers, and the increased foreman costs, right? They narrowed down the number of foremen per workers. Those are strictly termination costs. Those aren't intervention damages. One of the ways to think about an intervention is if the owner, and notice too on Section 17.2, it's in Section 17 of the contract. 17.1 is entitled inspection, right? So the two work hand in hand. If the owner's out on the job walking the site and he sees an unsafe condition, right? He sees a hole in the ground that's not properly barricaded. The owner has the right, because the owner doesn't control us, has the right to stop the work and say, hey, you better fix that, you better put up barricades. And in that event, we're responsible for the extra costs associated with the barricades to put around it. But what it doesn't mean is they can't intervene by terminating, right? To the extent they want to terminate this deal and hold us liable for excess completion costs, they had to provide the 3 written notices required by the contract. And recall this, with respect to our strict compliance arguments, it's undisputed in this case. We're not arguing whether these are conditions or covenants. It's undisputed in these cases that these are express conditions. And it's undisputed in this case that not one of the 3 written notices ever was given. And remember the jury findings. The jury failed to find that the first 2 written notices were given. It was never asked whether the 3rd written notice was given because that was undisputed at trial. Right? They rely on statements at the April 11th meeting, the oral statements. And it's also undisputed in this case that these written notice requirements never were waived, and they're valid and enforceable. Now, this court is fully well aware of the significance of express conditions. Just last year, there were 2 separate opinions from this court on the significance of express conditions, and albeit in those cases, in Chalker Energy and Energy Transfer, this court upheld and enforced express conditions to contract formation. But in those cases, this court correctly recognized that virtually every court term, this court recognizes and enforces Texas's strong public policy in favor of the freedom of contract. And in the Energy Transfer case, this court cited Mastech, where this court recognized correctly that an indispensable partner to freedom of contract is contract enforcement. And that's all we're asking you to do. Unlike the owner, Westlake Chemical, we're not asking you to read terms into this agreement or out of the agreement. We just want you to take the express terms that these parties agreed to and enforce them as written. Now, ironically, the Court of Appeals in this case, in an earlier opinion, which we cited in our briefing and will be cited below, actually states the rule that we want this court to adopt on the strict compliance standard. This is the Emerald Forest opinion. And in that case, the 14th Court of Appeals stated, when a contract provides for a particular form of notice, compliance with such provisions is a condition precedent to invoking the contract rights which are conditioned upon the notice. And that's the rule we would like the court to adopt in this case. The parties freely agreed that 3 separate written notices were required. And in this case, it is undisputed that not one of those 3 written notices ever was given. You should hold the owner to its word and enforce the terms of this agreement. They neither had the right to terminate the contract for default, and they didn't have the right to recover excess completion costs from us. That ought to have been a summary judgment issue. And instead, here we are 8 years later, still arguing about whether or not notice was given. The Court of Appeals completely dismissed the significance of written notice, which again, I pointed out in Berry versus McAdams. This court noted the significance is to provide certain indefinite information to the recipient and not to leave alleged oral notices to somebody's memory that will fade over time and transform it effectively into a fact issue for a jury when it ought to have been a question of law for the court to decide. Had these written notices been provided, we would have them here today, where we could look at them and determine from the unambiguous terms whether the notice was actually given. And that's the problem with the substantial compliance argument. It is really incompatible with freedom of contract, the substantial compliance doctrine is. And remember this when they come up here to argue today. They're asking you to rescue them from the terms of their own negotiated agreement, right? This is a sophisticated owner on a $500 million construction project that couldn't be bothered to comply with the terms of its own agreement. And as this court noted in Mastech, it's not this court's role to protect parties from their own agreements, but to enforce contracts that parties enter into freely and voluntarily. And that's all we're asking you to do today, is enforce the terms of this party's agreement.
Any other questions? Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Harris will present argument for the respondent.
Mr. Chief Justice, and may it please the court. James spent much of its argument suggesting there was no termination because Westlake paid the retainage. Those were the same arguments that were presented to the jury, which rejected them. But I would like to get back to the first principles of Texas law. Substantial compliance has long been the law in Texas. This court has applied the substantial compliance doctrine to contractual requirements for over 100 years. At the time this contract was signed, all Texas courts that addressed the issue had applied the substantial compliance doctrine to contractual notice provisions.
So let me ask you, so in answer to his last argument, and both of these parties are sophisticated parties, why shouldn't your client be held to the terms that he agreed to?
Because of the substantial compliance doctrine, Your Honor. Substantial compliance has long been the general rule in Texas. And again, every court that's considered the issue of whether the substantial compliance doctrine applies to a contractual notice provision, every court under Texas law, Texas courts as well as the Fifth Circuit and federal district courts, have held yes, it does apply. And there's a Fifth Circuit case that's on all fours. It's the South Texas Electrical Co-op case. And in that case, oral notice was given instead of the written notice specified in the contract. And the court held there that the substantial compliance doctrine applied. And again,
it seems like the question is sort of substantial compliance with what? Maybe substantial compliance does apply, but you're saying substantial compliance with a notice requirement.
Yes.
And they might say substantial compliance with a written notice requirement. And if you look at it that way, and there's no written notice, then there's no substantial compliance. I mean, the assumption is that your assumption is that notice is all that matters, but should we just assume the parties don't care about the written notice, or that the written part of the notice isn't important even though they provided for it? I mean, how do we determine which piece of the agreement has to be complied with substantially?
It's substantial compliance with the notice provision required under the contract. Here it was a written notice provision. So we're looking at whether there was substantial compliance with that written notice provision. And the test is first, is there actual notice? Did they actually learn about it? And this is a high burden. This is a hard test to prove. You've got to show they actually got notice. Then you've got to show that the purpose of the provision was satisfied and there was no harm by the method in which notice was given. Again, that's a high hurdle.
So in that rubric, my question is, why isn't the purpose of this provision written notice?
The purpose of the provision is to give them notice in case they're required to do something. For example, the first notice under the contract was to give notice that there was a serious safety violation. That puts them on notice that there's a safety violation so they can fix it. That's the purpose of the notice. They got actual notice. The purpose was fulfilled, said the jury, and there was no harm in the method in which the notice was delivered, also said the jury.
If they had added a sentence or two that said, we really care about written notice, would this be a different case?
There's a very easy way to do that, and we do this in contracts all the time. The most common example is time is of the essence, where that's added. But if you look at tab C of the bench book that I provided, if James wanted a rule of strict compliance to apply, all that they had to do was to add that language into the contract, and that would contractually override the substantial compliance doctrine. And we provided examples of cases where parties have done exactly that. Written notice shall be provided and strict compliance is required. You wouldn't be talking about the substantial compliance doctrine. That is the law in Texas. Substantial compliance is the general rule. Substantial compliance applies unless the parties contractually say, we want strict compliance. And the cases we've cited in the bench book show exactly that. It would have been very easy for James to have done that. If written notice was the only way it wanted notice done, if that sheet of paper, as opposed to sitting down and having a meeting and walking through it, was the only way they wanted notice, that was available to them under Texas law. And again, that was the law at the time this contract was signed in May 2012.
Does that apply to every contract between every kind of party?
Substantial compliance, Your Honor?
Your substantial compliance with a written notice requirement theory would apply to every contract, and not just construction or sophisticated parties, but I'm thinking landlord-tenant. You know, a lease says if you want to renew your lease, you got to submit written notice no less than 30 days before your lease expires, or 60 days before your lease expires. And if we adopt that theory, that rule of law that you say is the law, and it applies to every contract, then aren't we just inviting a plethora of lawsuits saying, oh, but I walked into the leasing agent's office and said, I'm going to renew my lease. And now, and then the landlord says, well, that's not good enough. The lease says you've got to give us written notice. No written notice, we've already leased your apartment. And now it's going to be a dispute every time he said, she said.
2 points with that, Your Honor. In some areas like landlord-tenant, I believe there probably are statutory requirements about what has to be done. So sometimes I think the legislature may have spoken. But as to whether this is going to open the floodgates of litigation, substantial compliance has been the general rule in this state for over 100 years. We're not asking the court to change the law. That has been the law. Substantial compliance is the general rule. And when you look specifically at notice provisions, you look at the courts that have interpreted that. You have the cases three cases out of the Dallas Court of Appeals. You've got 2 cases out of the Fifth Circuit. You've got several federal district courts. You have a case out of the Eastland Court of Appeals. Every court that has considered the issue has held that it applies. James has cited no case under Texas law that says that substantial compliance does not apply to a contractual notice provision. So again, that is the law. This contract incorporated Texas law when it was signed in May 2012. That was Texas law at the time. It was also Texas law that if you didn't want to have the substantial compliance doctrine apply, it's real easy. You say, and strict compliance is required. Just like if you have a timing provision and you mean January 1, not January 2, you better say January 1 and time is of the essence. The parties have the ability to do that.
I just go back to, your assumption is that the business purpose of this provision is to provide notice.
Yes.
And as Justice Boyd was sort of alluding to, I mean, couldn't it be the case that the business purpose is to provide written notice, that there is some substantive importance or relevance to the written notice that gives the parties certainty and comfort about what's happened, and that is wrapped up in the business purpose of this kind of a provision?
If you look at the cases talking about notice provision, it's often the purpose of the notice is so that a party can take some action with the notice. And here, for example, again, the first notice is that there's a serious safety violation. The purpose of that is not to give them a sheet of paper. The purpose of that is so that they know Westlake, in its reasonable opinion, believes that there is a serious safety violation so that James can then take remedial action. And again, we go back.
And there are some emails about that, but is there any writing that confirms that the termination was because of serious safety violations? In other words, there's getting back to what Justice Blacklock is saying, is there anything in writing about the reason for the termination? And could everyone, after an oral meeting, decide we're all walking away and not understand from that there are potentially significant legal consequences from everybody walking away?
Your Honor, the notice that was required, the termination notice, is very simple. Under 21.3, it was only that Westlake is elected to terminate the mechanical work. It wasn't required to give a reason. The reason is the reason is in the first notice that there is a serious safety violation. The second notice is that Westlake is not satisfied with the quality and the pace at which James is attempting to cure that. And the third notice is Westlake is terminating a portion of the work. That's all that's required under that notice. And as far as the written requirement, had the parties, after this meeting, simply typed up a memo and put down everything that was said in the meeting and given it to James, that would have satisfied the writing requirement. But we are still here also arguing about the sufficiency of the notice. So even if there was a writing, James is complaining about the sufficiency of the notice, which is a different issue than whether there's a writing, and we're going to have litigation because there's no writing. But if this same meeting had been put down in a writing, they're still going to be arguing about what the sufficiency is. But the jury found that actual notice was given that satisfied Section 21.3. That was a fact issue. Whether the notice given by Westlake in this case satisfied Section 21.3, and the jury said yes, it did. There was actual notice, the purpose was fulfilled, and importantly, there was no harm to James. And those are the factors that courts look at in determining whether there is substantial compliance.
Does your position effectively write Section 9.1 out of the agreement? I mean, it doesn't mean anything anymore. It's just, it's not there at all under your theory.
It doesn't, Your Honor, because again, the substantial compliance doctrine applies. And substantial compliance is the legal equivalent of full compliance because the deviation is not material whenever there's actual notice, the purpose was fulfilled, and there's no harm. And that's the legal equivalent. And we've cited cases in TAP.
But then the point is, assuming those three elements are met, it is not necessary that any notice given pursuant to this contract shall be in writing. That just doesn't mean anything anymore.
If the high hurdle of substantial compliance is satisfied, then the written requirement of the notice is deemed to be not material, Your Honor. Justice Bland, you asked a question earlier about the retainage and Section 6.2, and I want to kind of come back to that. In closing, James argued that the retainage constituted a ratification. That's the way the retainage was argued in this case. And again, that was an issue for the jury, and it's in volume 19, pages 178 to 79. Importantly, the issue of retainage, and as you point out, Your Honor, section 6.2, payment is not evidence of performance or acceptance of work. So we know it's not relevant under the contract. The retainage issue doesn't go to the termination issue. What it goes to is question 3F in the jury charge, which is waiver, estoppel, or ratification. So this whole issue of retainage, in fact, is a waiver or ratification argument. That was submitted to the jury. The jury found against James, and James has not appealed those findings. So the retainage issue is not relevant to the termination issue in this case.
Agree with your opposing counsel that all of the damages submitted to the jury were termination costs and not intervention damages?
No, Your Honor. They were damages that were required because Westlake had to have someone come in and perform the rest of its work. And if you look at the damages required under intervention, it was the contract required James to reimburse Westlake for all costs associated with the intervention, which include costs by any third party. I mean, the cost provision in section 17.2 for the intervention is very broad, and the jury in this case found the same damages for the termination provision and the intervention provision, and that's why that is an alternative ground for affirmance. Unless there are any more questions on the substantial compliance or termination, I'd like to take a few minutes and talk about the counterclaim under the waiver of consequential damages provision. The Court of Appeals correctly concluded that James cannot recover on its counterclaim under the waiver of consequential damages provision. James's counterclaim depends on a determination that the waiver of consequential damages is in fact a covenant not to sue that gives rise to a breach of contract claim. The plain language in this contract shows that the parties intended this provision to be a waiver of consequential damages. The provision is entitled Waiver of Consequential Damages and establishes the parties will not be liable to each other for consequential damages. The waiver provision is separated into two clauses. The first clause establishes that the parties waive liability for consequential damages, and the second clause precludes any argument that the waiver is ineffective because of the cause of action that's pleaded, and it also preserves claims for consequential damages if they arise out of gross negligence or willful misconduct. But James wants...
Under that theory, your theory that the second half of Section 26 really defines the scope of what is being waived, could you respond to the argument that that effectively reads out the middle kind of connecting phrase there, and no claim shall be made? What's your response to that?
It doesn't, Your Honor, because this clause is set up, it's really a compound sentence with two full pieces of it. And if you look up until from the neither company all the way through right before and no claim shall be made, that is what we're referring to as the first clause, and this is what the Court of Appeals found. And then it restates, and no claim shall be made by either the company or contractor, regardless of the nature of the claim. And what that does is defining the scope of the waiver. It doesn't write it out. And what James wants to do is to focus on that clause, no claim shall be made, that phrase in isolation, which of course this court shouldn't do. It should look at that in context of the entire provision. And nothing...
Isn't it another way to read it, though, and here's what I'm trying to get at. Couldn't you have accomplished what you say this provision accomplishes by just beginning with the word regardless immediately after the work and skipping and no claim shall be made? Wouldn't that accomplish what you say this does?
That would, I mean, it would in essence be rewriting. It would take it from, right now it's structured as a compound sentence where you really have two independent sentences, and it would take the first clause and have the second clause, the portion that's left of it, be modifying only that first part. So it would basically change the structure of the provision. But I think the more important thing in looking at the no claim shall be made, Your Honor, is what those words mean. Because there was a dissent in the Court of Appeals. And the dissent said that was a covenant not to sue, but I think we need to look at what that language is. And courts have interpreted no claim shall be made. Numerous courts have interpreted that in a waiver of consequential damages provision, and all of the courts have said that it bars the plaintiff from recovering consequential damages on a claim and does not address the issue of whether the plaintiff is prohibited from bringing a lawsuit in the first instance. Because to have a covenant not to sue, you need to have language saying that a party promises not to sue. If you look at the cases that James has relied on in this case, they all have that covenant not to sue language. They say things like covenant not to sue, covenant never to make the claim the basis of a suit, covenant neither to institute legal action. The focus of that is whether there is a covenant not to bring a suit, and that was the phrase that this court used in Westergren in deciding whether something was a release or could be a covenant not to sue. It's that language promising not to sue, and all of the cases that James cites has that express language in it. That is what is missing here, and when you look at how the courts have interpreted, and we have set out several of the cases in tab F of our bench book, and I would like to draw the court's attention to the Fifth Circuit case in the Nisho-Iwa decision. There, the court determined that the language, no claim shall be made under any circumstances for indirect and consequential damage, barred the recovery of indirect and consequential damage. It didn't bar the filing of a lawsuit. And that is what is required under Westergren, is to have language that bars a party from bringing suit. And that is what is absent here. And if you look at the cases that we've cited in tab F, it bars the recovery. It bars recovery. It limits liability. It bars recovery. It precludes recovery. That has nothing to do with barring a party from bringing a suit. That clause simply doesn't say that, and no claim shall be made is used not infrequently in contracts. And so for this court to hold that a covenant not to sue is created by no claim shall be made would be changing the law, and especially here where this provision says nothing about not bringing suit. I would also like to point out that James has not cited any case in any jurisdiction that involves a covenant not to sue for consequential damages. And I think the reason for that should be plain, because parties often disagree about what does and doesn't constitute consequential damages. I mean, here, for example, we're 7 years into the litigation, still arguing about whether damages are or aren't constitutional damages. So James's position here that the parties intended to pioneer an unheard of legal device by creating a covenant not to sue for consequential damages and then burying it, taking one phrase and dropping it in the middle of a provision entitled waiver of consequential damages, isn't reasonable and isn't supported by the contract language. Unless the court has any further questions, we pray that this court affirm the judgment of the Court of Appeals.
Any other questions? Thank you, Mr. Harris. Mr. Coates, I believe you have 4 minutes.
I'd like to correct a misstatement that opposing counsel stated. He said we never cited anything in our brief holding that strict compliance is the default rule. Pages 25 and 26 of our merits brief cite plenty of cases that the court can refer to. But in regards to his argument that the default is substantial compliance, Williston disagrees. He says in section 38.6 that when you agree to an express condition, the condition naturally means exact and full completion, meaning that the default is strict compliance. And if the parties want to agree for substantial compliance, they're free to. And here they didn't. And Justice Boyd, you correctly pointed out, if you accept their substantial compliance arguments, section 9.1 of the contract means nothing. Now here's the real problem with their substantial compliance arguments. They want vague statements at weekly safety meetings to supplant clear and unequivocal written notices.
What if they weren't vague? What if it was undisputed that your client received clear, unambiguous, direct oral notice of the 3 notices required?
The same contract terms, identical?
Saying, yeah, 9.1 is still there. You keep referring to vague, and there was an issue, but the jury found
Right.
otherwise. So let's assume very clear, direct, unambiguous, they gave you the notice required, it just wasn't in writing. You'd still be taking the same position, wouldn't you?
Yes.
Okay, so it doesn't matter if it's vague or not.
Right, but it should make a difference because these provisions are in here for a purpose, right? You know, the Court of Appeals is completely dismissive of this fact that this should be in writing. And this gets to the policy of these sorts of provisions, right? We want things to be clear and unequivocal. This should have been a question of law for the court, not a question of fact for a jury. If you allow substantial compliance in a case like this, you're going to have a fact question in every case. And you're probably going to have scenarios like this where you're going to be litigating whether or not an oral statement constituted notice almost a decade after the fact. You don't want to relegate these things to a swearing match between parties, between what was said and what was not said. And that's the real problem with the substantial compliance doctrine. I'd also like to point out.
Would you say that for strict compliance, it would have to say notice of a default at the top? Could it say something like removing the work may be necessary to prevent recurring incidents, and that would be, if that was in writing?
They were very careful at trial never to use the word terminate because their own witnesses admitted that word is nowhere in the record, right? They kept using the word remove. We would contend, as you correctly noted earlier, there are other provisions of the contract that allowed them to transfer work from us to another contractor. I would point you to sections 1.2 and 15.7 of the agreement, where we contend that that's exactly what happened. They took work, they either didn't assign further work to us, or they took work from us and gave it to the replacement, or the alleged replacement turner who was already doing other work on the job. We would contend that that wasn't notice of a termination for default, especially because the prior notices weren't given. Remember, he said we necessarily would have known by the time we received that last notice that it was a termination for default because of the prior ones, and we contend none of them were given.
So what would you say would have constituted notice? It would have had to have said default and the cause, terminate and the cause, or just terminate?
The contract required them, this is right out of 21.3, it requires them to specifically cite the breach, right? This has to be in the notice itself, so it has to tell you, and remember, it's not just an incident, it's a violation. This contract equates a default with a breach with a violation. So it has to tell you not that there's just an incident on the job, there's been a violation that needs to be addressed. And I'd like to point you to Oral Argument Exhibit 5. It's an excerpt of Scott Campbell's testimony. Scott Campbell is their technical manager on the job. He's the guy that supposedly delivered the statements at the April 11th meeting, right, where we were supposed to have been informed that we were terminated for default. He was asked, after we left the mechanical portion of the job and were merely performing the civil work, he was asked, apparently there were safety incidents that kept occurring with Turner, with MMR, and with Petrin. He was asked, you would have regular safety meetings with these folks. And I'd ask you to look at that testimony because he confirms what we said. You'd have regular meetings and no one thought that these were notices of default or termination at the time. So we would ask for you to reverse and render a take-nothing judgment on their claims, reverse as to our counterclaim and remand for further proceedings to the Court of Appeals. Thank you.
Any other questions? Thank you, Mr. Golds. The case is submitted, and the court will take a brief recess.
All rise.